So, big story turning into a bigger story apparently by the hour. Last night, the English Montreal School Board held an executive meeting, decided to move forward on their challenge to Bill 21. That's the state secularism law, which prohibits, of course, public sector workers in positions of authority, and that means teachers, from wearing religious symbols on the job. They're going to appeal this all the way to the Canadian Supreme Court. So let me start with that part of the story first. Joe Ortona is the chair of the English Montreal School Board. Joe, thank you for being here.
Thanks for having me on.
Yeah, it was not unanimous last night, right? There were a couple of questions as to whether this was the right thing to do or the appropriate thing to do at this meeting.
Well, the vote was 12-1, so I think that's not unanimous, but I think it's still a significant majority of commissioners who were in favor of taking this to the Supreme Court, and not only because we feel and always felt that this law discriminates against the constitutional rights of Quebecers and discriminates against our right to manage and control our system and the exclusive right to hire the teachers that we want, protected by Section 23, but also because, after reading the judgment of the Court of Appeal, there are some serious questions there that make this ruling subject to appeal, and we think the Supreme Court should hear it and end the debate once and for all about the constitutionality of this bill.
So let me go back to the ruling, the one that you're referring to. What in there that you looked at, or give me a couple of points if you can, said to you, yeah, you know what, based on this ruling, we think we have a case, we should move forward?
Well, the in Superior Court, the judge gave a very broad interpretation of Section 23, which seems to be consistent with what the Supreme Court has done over the course of the last 35 years. Spoke about the importance of the vitality of both linguistic communities all across Canada, that the English minority here, like the French minority in the provinces outside Quebec, have a right to thrive, and that's important. And in order to protect that in the public education system, well, you have to have a school system that is strong, where the minority community really has certain powers and control over that. The Court of Appeal seemed to give a much more restrictive interpretation of Section 23, and obviously the Supreme Court's going to have to take a look at that. We also think that the judge rendered a lot of decision based on the evidence that was heard in terms of the benefits of children, not just children of religious minorities or visible minorities, but all children, and the benefits of them being exposed to teachers of different cultures and different customs. We presented overwhelming evidence in that regard. The judge found in our favor because the Attorney General of Quebec did not present any evidence to contradict that whatsoever, and it seems that the Court of Appeal sort of didn't consider that at all in their decision. So the trial judge is the judge who's best placed to make the findings of fact when it comes to the evidence. And so, we look at the end of all of that. I think those are two pretty good examples. The Supreme Court is going to have to look at happened here in Superior Court at the Court of Appeal and determine once and for all, is this bill constitutional or not? And we're finally going to have a final answer at some point.
Joe, I know we talked even last year when this was a possibility, theoretically, of going to the Supreme Court. And I remember, and I played this clip earlier in the show today, the then Justice Minister David Lametti, who actually said, when asked, I might as well play the clip for you if you didn't hear it, and we asked what's going to happen if and when this does get to the Supreme Court with respect to the federal government. He said this:
if the Bill 21 litigation gets to the Supreme Court, once it's been ruled on by the Quebec Court of Appeal, that we will be there. It will be de facto a national issue, and we will be there to make arguments generally, but in particular about the preemptive use of the notwithstanding clause.
So, Joe, with respect to the federal government's intention then, and I haven't heard anything suggesting it might change, was this decision made with that in mind, that they would be there to support, or does that not enter into this?
Look, from our perspective, and of course, I believe that once something gets to the Supreme Court, obviously any party that has even a slight interest in the matter, usually tries to see if they can intervene and have their points heard before the justices of the court. Because, cases that go to the Supreme Court, it's not nothing. Those are really important cases that have a national interest, an important impact upon, the law and constitutional interpretation over the course of the next 50 years. So that's expected, but I and others did not take that into consideration. What we took into consideration was the decision that we got from the Court of Appeal. Are there grounds to appeal here? Is there anything in their findings of fact or in their interpretation of the law or of the Constitution that could open the door for the Supreme Court to want to hear this? And we think that there is, and that's the only thing that we took into consideration.
I mentioned today, we all heard this morning, the Justice Minister wasted no time in, commenting on what was going on, and you've decided to do this. He also stuck his finger at the federal government and said, hey, you know what, this is not his words. They should mind their own business. This doesn't concern the federal government. But he did bring up cost here, and this is not inconsequential, right? This is going to involve, I think the number was so far you spent, about $1.3 million on this. By the time you're all done, it'll be closer to $2 million. Is that accurate?
No, because we don't know how much it's going to be at the end. There's no indication that this is going to cost $2 million at the end. I don't know where that figure comes from. The truth is, when you get to the Supreme Court, you're very limited in your written submissions and the time for you to make your oral submissions. This is not something that is going to be weeks long like it was at the Court of Appeal. We're talking about approximately a 1 or 2 day hearing. So it's going to be much less expensive than it's been up until now. But, that's the kind of thing that I would expect from the Justice Minister or from anybody else in the CAQ government. They like to point the finger always in the other direction. This is costing them a pretty penny too. And when they lost in first instance, this Justice Minister announced that he was going to appeal before he even read the judgment. So, I take those kind of weak arguments with a grain of salt.
Okay, but that figure of $1.3 million up until now, that's accurate?
Yes, it is.
Okay.
But you have to consider that that's $1.3 million over the course of 5 years. We have an annual budget of $450 million a year. So you're talking about $1.3 million over an overall accumulated budget of over $2.2 billion.
Right.
So you're talking about I'm trying to do the math quickly.
Less
in my
than
head
1%.
Oh yeah,
okay.
It's like 1/100th of 1%, and maybe even less than that.
So it must really bother you then to hear, and this is what Simon Jolin-Barrette said today. After pointing at the federal government, telling them to mind their own business, he felt it okay to take a shot at the EMSB. He said this:
"There's really a question about the funding, the public funding, that we have a bill that is regularly adopted by the National Assembly, and that's public money. And the Court of Appeal say the bill is valid, and I think they are more than $1 million of billing of that public money. There are some questions that should be asked."
Are there some questions that should be asked, Joe? What's he saying?
Yeah, the question I would ask is, all of these bills that he's adopted that many times have turned out to be unconstitutional, how much money and how much time has that cost the government of Quebec, who just adopted the largest deficit budget, I think, in Quebec's history? Mm-hmm. Do I need to list them? Bill 40, Bill 96, numerous injunctions have been granted over that. The list goes on and on and on. And this idea that because it was adopted at the National Assembly, it becomes untouchable. I'm sorry, but the CAQ government doesn't shy away from sticking its nose in the affairs that fall under federal jurisdiction, and they've taken the Canadian government to court. All of that costs money. The court system costs money. But that's what the court system is there for. It's to make sure that constitutional rights are respected, to make sure that laws respect the Constitution, that we don't overstep on the jurisdiction of the federal or of the provinces, and you know what? That we don't overstep on the jurisdiction of the linguistic minorities' right to manage and control their schools either.
Joe, last question. With respect to time frame, I know you can't know exactly. Is this about years? Is it about months? Do we have a clue?
I would say it's hard to predict, but I guess that's going to depend on the complexity of the hearings and how long it's going to take for the Supreme Court to render a decision. But sometime around 2025, I would expect it to be heard, and either at the end of 2025 or maybe in early 2026, we can finally have a decision here once and for all.
And in a perfect world, if this decision goes for you, it's a matter of you being able to control your own future, hire whoever you want, and maintain whatever English you want as it existed before Bill 21.
Sure, obviously, and in a perfect world, the law would be struck down across the entire province of Quebec, and it would have no validity and no effect.
All right, and we will leave it there. Joe Ortona, chair of the EMSB. Joe, thanks so much. I appreciate it.
Thank you.